And Bob too, I could introduce him, and he really needs very little introduction for most of us here. He has been a professor at English scholar, editor of the English Quarterly. Very interested in some of the copyright issues that were swirling around his work. Also here at CU. First, the Yale Law School. He became the executive editor of the Yale Law Journal. After serving on the Second Circuit, practicing as a lawyer in social work next year, and practiced as Attorney Condors for several years. And then moved to a firm in internet and work, particularly his work with the installation state, or against the installation state, which I mentioned. And Bob and I started talking.
Thank you very much, Janet, for that kind introduction. It's great to see. Well, my experience of Tulsa is so varied that I see various levels of relationships in the audience. I see former students in the English department. I see current students in the law school. I see current colleagues in the law school, and I see former colleagues from the law firm I worked with, Derner Saunders. It's great to see all of you. It's kind of like, you know, a huge reunion to have you here today. I'm going to talk about copyright misuse, which is an emerging doctrine in copyright law, and it's one that I think that affects all of us in a certain respect. In that copyright law itself is coming to affect all of us more and more. I mean, you don't have to look far to see the constant news regarding copyright law. We live in a time of expanding intellectual property rights. Congress has only recently passed, and the President has signed a bill authorizing an increase in the amount of statutory damages that are available for copyright infringement, strongly increasing those damages. The bill also establishes a new position called Intellectual Property Enforcement Coordinator within the Office of the President, a copyright czar, as it's being described in the news. The recording industry continues to file lawsuits that seek to punish unlawful downloading of digital music against both individuals and online services. In the last few days only, Google has reached an agreement with publishers' representatives to settle a long-standing lawsuit over Google Books' book scanning project. And it could be, if it's approved, that settlement could be a very important step in making books available over the Internet. So when you first encounter the term copyright misuse, I wouldn't be surprised if you thought that it had to do with some sort of aggravated copyright infringement, something that users of copyrights are doing to earn the name copyright misuse. Not so. Copyright misuse is a doctrine that tilts the balance of rights and duties back in the opposite direction, taking copyright owners to task when they go too far in seeking to enforce their rights. But how far can a copyright owner go before he or she becomes a misuser of her property rights? That's what I'd like to talk about today, if my slides will work. I'm warming up here, I guess. To begin with, copyright misuse is really kind of like fair use in the regard that it's a doctrine that is evolving and has evolved within the courts. It's a judge-made equitable rule. Fair use is that too. When you are accused of infringing a copyright, very often you bring a fair use you allege a fair use defense. You know, my use of this copyright is not infringing because it serves some social purpose, some purpose of scholarly commentary or criticism. And in order to determine that defense, the court will look to its equitable factors and the facts of the case to decide it. Copyright misuse is similar. It's not based on any kind of statute, except in the rare circumstance when it takes the form of an antitrust type of defense. But for the most part, it does not. Most of the cases involve something else, and so it is really in the discretion of the courts to find that copyright misuse exists and to evolve the doctrine as it goes along. There are really two general approaches. I just mentioned one, which has to do with anti-competitive behavior, antitrust laws. The other is an approach that addresses the public policy underlying copyrights. Most of us think of copyrights as a property right, but if you think about it a little bit, copyrights are also really about making works available to the public with a certain amount of protection for the owners of the copyrights of those works. At least that was the traditional policy for awarding a copyright to an author or a creator. This latter approach is really the one I'll be talking about mostly today, this one that addresses a misuse that involves the public policy underlying copyrights. Earlier in the last century, copyright misuse, when it occurred, and you first see it in cases in the 40s and then up through the 60s, they tend to have to do with something more like antitrust. You'll see them in cases involving price fixing or tying situations, often involving the movie industry and its rules for distributing movies for theatrical release. At that time, copyright misuse was strongly tied to really its older cousin called patent misuse. But it has evolved since, and in the last few years has begun really to take on a life of its own in the direction of this public policy angle, which is the one, as I say, that I'll be discussing today. What you see here, public policy, this is from the Lasercomb case, public policy behind the grant of copyright protection forbids the use of the copyright to secure an exclusive right or limited monopoly not granted by the Copyright Office, in which it is contrary to public policy to grant. You see here really two things that are being highlighted, two articulations of the public policy approach. One having to do with extending or trying to secure an exclusive right in your copyright that you are not given normally under the statute, so trying to extend your rights beyond where they belong, and also a notion of public policy. Historically, this is moving slowly, unfortunately, historically, copyright misuse has been thought of by courts as being related to something called unclean hands. There's a defense in copyright, in the law generally, an equitable defense called unclean hands, and that is when the person who is suing you has done something, him or herself, that is unsavory, and therefore the court should not allow the lawsuit or the request for an injunction, for example, to go forward. This unclean hands version of copyright misuse emerged in a case that involved Howard Hughes, one of the great, of course, private individuals in history, obsessively sought to maintain his privacy. So much so that when he learned that Random House was about to publish a biography of him back in the 60s, he went about to create a company which he called Rosemont Enterprises the company was formed to buy up a bunch of copyrights that had, for articles and biographies that had come out in magazines and elsewhere. And once he, or his company, became the owner of these copyrights, he then turned around and threatened Random House by saying, now you can't publish this biography because I own all these copyrights in biographies of myself, and you will be infringing on my copyrights if you proceed with this. I think there's some irony in the unclean hands being associated with Howard Hughes. As you may remember, he was also a clean freak who created zones in his house that were germ-free zones, certain chairs that he sat in naked in order to avoid the germs. So when he was found to have, or at least one of the judges on the panel believed that he was guilty of unclean hands, that must have been a particularly galling thing for him. It turned out that the case didn't actually go off on unclean hands. It was decided that what the Random House's biography was doing was a fair use, and that didn't prevent Judge Lombard on the Second Circuit from writing a concurring opinion in which he strongly condemned this attempt to use a copyright to suppress discussion of a public figure. And he said, Judge Lombard did, as part of his concurrence, the court should not tolerate any attempt at interference with the public's right to be informed regarding matters of general interest when anyone seeks to use the copyright statute, which was designed to protect interests of quite a different nature. Now, this is an earlier case. It is related to copyright misuse, really an unclean hands concept, but it looks forward to some of the current development of the copyright misuse doctrine because it has to do particularly with attempting to suppress the use of facts that are, of course, not copyrighted, and the proliferation of thought and discussion about a topic, which, of course, is not copyrighted either. To use a copyright to try to stamp that out is something that the courts are beginning to look at more seriously. I want to talk about a number of types of misuse, just to give you some examples of this. Quite a bit of it has had to do with the software industry. In the Lasercomb case, which is in many ways the modern case that has really taken the copyright misuse defense to a new level, in Lasercomb, the plaintiff, Lasercomb, produced and sold a software program called Interaction that facilitated the design and manufacture of steel rule dies for cutting paper and cardboard, this kind of thing that you see an image of here. The defendant was named Holiday Steel, and it was a competitor. It had licensed this Interaction software from Lasercomb, but then it decided to go off on its own and become even more independent as a competitor and started to create its own software, which incidentally was copied from Interaction almost completely, and ignored its license and its obligations. When it was sued for copyright infringement by Lasercomb, Holiday Steel defended itself by arguing that Lasercomb had been misusing its copyrights by entering into license agreements that required licensees to agree not to develop or sell for 99 years any computer-assisted die-making software without Lasercomb's written consent. So that means not only that the licensees could not misuse Lasercomb's copyrighted software, but they couldn't create any competing software, whether or not it had any relationship to the copyright. And you see, that is a sort of anti-competitive problem. And the court agreed that this was a problem and refused to allow Lasercomb to enforce its copyrights here. And it's important, this will come up a bit later, that Holiday Steel, though it was a licensee of Lasercomb, had not actually signed the license agreement. So Holiday Steel was not bound by the 99 non-competition provision. Yet, because this is considered to be such a serious problem when you try to extend your copyrights beyond their scope in this way, you can actually raise other licensees' problems other than your own. You have very broad standing in that respect to raise the copyright misuse defense. It's kind of a whistleblowing opportunity. What Lasercomb, the court specifically held that it was a misuse for Lasercomb to have sought by means of its software copyright two things. One, to control competition in an area outside of the copyright, that is the idea of computer-assisted die manufacture, and two, to extend its monopoly from the expression embodied in the software to the idea which the software expresses. And again, this looks to two dimensions of this copyright misuse defense. On the one hand, it looks to this notion of anti-competitiveness, which, of course, our antitrust laws are specifically designed to protect against. But also it looks more specifically at the copyrights themselves and says that copyrights give you certain rights, but we know that copyrights also exclude a lot of things from the copyright owner's province of protection. And so when you, as a copyright owner, try to cross over into that, as it were, forbidden zone, that can be a problem too. So a problem within copyright as well as an anti-competitive issue. Another example, again taken from the software industry, in the Fifth Circuit case of Alcatel, which was involved in the manufacture of telecommunications equipment, went ahead and sued DGI, which was a competitor in this industry. Alcatel manufactured and sold telephone switching systems that routed long-distance calls and were run by operating system software. The customer would have to license this software in order to use the telephone switch system. Alcatel also made microprocessor cards that apparently enhanced the operation of the long-distance switching mechanism. But the microprocessor cards weren't protected by any intellectual property right, not copyright, not patent. They were unprotected, but they were these associated features. DGI came along and through reverse engineering, which is legal, it's not a copyright infringement, reverse engineering produced and sold competing cards that worked with the Alcatel switches. Then when Alcatel later went and upgraded its copyrighted operating system, DGI made some copies of this operating system in order to keep its cards compatible and up to date. Alcatel then sued for copyright infringement, and the jury agreed this was copyright infringement. The Fifth Circuit, though, reversed at least the grant of the injunction and held that Alcatel's license agreement extended copyright control from its operating system that was protected by copyright to its microprocessor cards, which were protected by nothing. And that, again, was a type of anti-competitive tying type behavior, attempting to extend this out, one right out to something that is not protected. In fact, anyone could compete against those microprocessor cards. This even hit the AMA, the American Medical Association. The American Medical Association owns a copyright in its coding system for medical procedures. They had registered this coding system for copyright and they licensed it to a number of entities, including federal agencies. As part of that license agreement, they require that the licensee not use any other system of procedure for reporting physicians' services. Once again, you see the relationship to these other cases. When an entity called Practice Management got into a tangle with the AMA, it sued for a declaration that the AMA's coding system was both uncopyrightable and that in any event, the license that the AMA was using was an abuse of its copyright by requiring licensees to use its coding system to the exclusion of any other coding system, even though those other coding systems were not protected by any copyright owned by the AMA. The Ninth Circuit, in this case, adopted the copyright misuse defense and held that the AMA had been guilty of violating this doctrine. And you probably are not surprised to learn that the defense has been offered by defendants in the many digital download copyright infringement cases that have been going on. Of course, the most famous of these, and one of the earliest, was the Napster case. And I don't have to tell you about Napster. Probably you've all been infringers of copyrights using Napster or LimeWire or something like that. But one of the defenses offered by Napster in that lawsuit was that Napster had been required to enter into a licensing agreement with a number of record companies, a kind of joint venture. And it raised as a defense that this licensing agreement that they were required to sign forbade them from entering into, from obtaining music from any other source. In other words, again, a kind of cartel, a kind of anti-competitive group of which they were required to be a member. And though this aspect of the case went away, at least at that stage, the Judge Marilyn Patel in the Northern District of California said that they could pursue discovery on the basis of that copyright misuse angle. So there is at least some precedent on the books for using copyright misuse in this context of digital downloads. Now, let me tell you, it doesn't usually work. Most often, a lot of these cases, as you probably know, are the recording industry bringing lawsuits against individuals that have been downloading on their own computers. Sometimes grandmothers, we hear these stories about grandmothers getting sued because their grandchild has been using their computer, and then they try to defend that, I didn't do the infringing. Some of these cases are really kind of heartbreaking. You have huge statutory damage awards against individuals. But these individuals are often bringing a copyright misuse defense saying that, they've been sued here by 3 record companies, and that means that the record companies are joining in a kind of illegal cartel to sue people and obtain damages from people, and that all these lawsuits, these many hundreds of lawsuits that they've been bringing, shows a kind of persistent anti-competitive behavior. That has not, for the most part, gotten any traction, as you might imagine. Again, copyright misuse is a developing and I think a robust defense, but it's not one that will simply, overtake completely the rules of copyright infringement. Censorship has become an issue in copyright misuse defenses. Let me give you an example of the Video Pipeline case. Video Pipeline was a licensee of Disney. And what Video Pipeline did was to create movie trailers for Disney and to distribute these movie trailers. Well, Video Pipeline got it into its head to start doing this online, so it created an online presence and began to offer movie trailers downloadable from the internet. And Disney at that point stepped in and said, "You stepped beyond the license agreement. We didn't say you could do this online. It was simply in the brick and mortar world that you could distribute these movies." For a while, Video Pipeline complied with Disney's demands, and then they sort of, went off the reservation and decided, we'll just create our own movie clips, and we'll put them online, and that can't harm anybody because we've created our own movie clips. Unfortunately, they used Disney movies to concoct these movie clips, so Disney once again threatened. At that point, Video Pipeline brought its own lawsuit for a declaratory judgment. They said, we want the court to tell us that our video clips are both a fair use, and that Disney's licenses that it entered into with us and with others were copyright misuse, because those licenses, and you can maybe imagine this from Disney and its attempt to police its image, the licenses required that any licensee not criticize or in any way attack the name and the image of Walt Disney and Mickey Mouse and so forth. The Video Pipeline was saying, well, these These license agreements are a copyright misuse because they're trying to extend their copyright out from an economic right and turn it into an instrument of suppressing public discussion. Well, the court in the Third Circuit did adopt here the copyright misuse defense in the Third Circuit, but it refused to apply it to these facts. It said that while the licenses forbade criticism of Disney on the licensees' websites, it didn't forbid the licensees from criticizing Disney in other venues. So the licensee could create a separate website that had nothing to do with providing Disney products, and therefore criticize Disney on that, or it could do so in the brick and mortar world. And the court found that there was no evidence that the public would be deprived of criticism of Disney if these license agreements were enforced. So I guess the idea was it was one of those kind of time and place issues where a restriction of speech over here is not an infringement. It doesn't violate the First Amendment if you're allowed to, if there's time and space to do the to have the speech that you want to make. Another case that is very interesting in this regard is the wire data case coming up out of the federal court in Wisconsin and came to the Seventh Circuit. This was a case in which Assessment Technologies owned the copyright in some software that was used essentially to collect and organize data. And this was licensed to a number of Wisconsin municipalities for the organizing of real estate tax assessment data. So they would use this stuff, and they would punch in their data about homeowners' assessments. Well, Wire Data had an interest in collecting this data about real estate assessments, and it contacted the municipalities and said, "Can you provide the data?" Now, normally the municipalities would be happy to do this. There was no problem with that at all, but the municipalities became worried that because they used this assessment technology software to organize their data, that they would probably be making some incidental copies of that in the process of providing the data, and they might be accused of copyright infringement. It turned out that Assessment Technologies first sued the municipalities in state court, saying that they couldn't, they would be in violation of their license agreements and so forth, and then turned around and sued Wire Data in federal court for copyright infringement. The case actually went in favor of Wire Data, but not on the ground of copyright misuse, on a different basis. But Judge Posner got so upset about this attempt to use by Assessment Technologies to use its software to stop people from obtaining what would otherwise be lawful, unprotected public domain data, that he actually spent a good bit of that opinion writing about how copyright misuse could be a problem here if it were really the determining issue in the case. Posner stated that by bringing a lawsuit to prevent Wire Data from obtaining unprotected data that Assessment Technologies had not itself gathered, Assessment Technologies was flirting with copyright misuse, as Posner put it. Quote, for a copyright owner to use an infringement suit to obtain property protection, herein data that copyright law clearly does not confer, hoping to force a settlement or even achieve an outright victory over an opponent that may lack the resources or the legal sophistication to resist effectively, is an abusive process. An interesting sort of uniting of copyright misuse to the notion of abusing the legal system by bringing a lawsuit of this sort based on these facts. The Seventh Circuit has not fully adopted the copyright misuse defense, except in a more limited way, but this case showed that when the right case comes along, it most likely will. Now I want to talk to you about a case close to my own heart and my own professional activities for the last several years. The case of Professor Schloss versus the estate of James Joyce. There's a Stanford English professor named Carol Loeb Schloss, who's been a friend of mine and a colleague for many years as a Joyce scholar, and I have known her probably for 15 years or so. She took it upon herself to write a biography of the daughter of James Joyce, a woman named Lucia Joyce, who was a very interesting, very troubled woman who had a short career, although a successful career as a dancer in Paris in the 20s, and she also did some other things. It's generally thought that she was overtaken in her 20s or early 30s by what we now think is some form of schizophrenia, and wound up being institutionalized for the rest of her life. Carol Schloss spent years researching this biography in the teeth of strong opposition from the James Joyce estate. Now, just as an aside, the James Joyce estate, and I know this from my former career as a Joyce scholar and editor of the James Joyce Quarterly, as Janet mentioned, the James Joyce estate has a hate-on for scholarship on James Joyce. Now, why they do exactly, I don't know. The estate is in the hands entirely of Stephen James Joyce, who is the grandson and the sole surviving heir of James Joyce. And he simply hates almost all scholarship that comes out on Joyce. But what he really hates is biographical scholarship about Joyce or any member of the family, because he considers this to be an invasion of the privacy of his family. He defines privacy very broadly to include people who have been in the grave for 60 or 70 years, and who have also become major public figures. I myself have been on the receiving end of some of his incredibly nasty letters. Very, very frightening for somebody who doesn't have any legal knowledge, and I think one of the things that may have driven me to want to learn about the law was because of this aggressive behavior on the part of a copyright owner who owned copyrights that were pivotal for the understanding of an important figure in 20th century literature and culture. When it became clear that Farrar, Straus, and Giroux, publishers, were going to publish Carol Schloss's book, the Joyce estate, Stephen Joyce that is, began bombarding people with nasty letters. They sent letters to Carol Schloss herself, to Carol Schloss's publisher, to Carol Schloss's publisher's lawyer, to Professor Schloss's provost at Stanford. In other words, this was a broad campaign to threaten a book that they had not even seen, and to try to discourage the project from going forward. And what they did is the estate cited its copyrights in James Joyce's writings, and its alleged ownership of copyrights in unpublished and sometimes published Lucia Joyce writings. She had written a number of poignant memoirs of her life from the institutions in which she was confined. And they were crucial, of course, to understanding her life. And so frightened did the publishers become that they cut out a fair amount of material, quoted material, from the book before it was published. So the book as published was not something that Professor Schloss was in some respects happy about, because here was a scholar who was trying to make some points about Lucia Joyce, but had to make them, at least some of them, in the absence of being able to quote the documentary evidence. Well, she was so upset about this that she decided after the publication to try to rectify matters by creating a website that would be the entire Lucia Joyce project, where she would restore on the website the material that she had been forced by this pressure to trim out of her book. When the Joyce estate learned about that, they once again started embarking on their letter campaign. And it's at that point that the Stanford Fair Use Project and the Center for Internet and Technology, under Lawrence Lessig's directorship, decided to take Professor Schloss's case on And I received a call when this was when I was with Derner Saunders around 2006 or so, asking if I would be and our law firm would be interested in helping in this lawsuit. We were interested in doing that. We got involved in it. I eventually went out to San Francisco and continued it with the law firm out there. And what the lawsuit was brought by Carol Schloss as a declaratory judgment action, seeking a declaration from the court that not only was what she was doing on her website a fair use, but what the Joyce estate had been doing to her and to other scholars for years was blatant copyright misuse. But she alleged were a number of things, of kinds of copyright misuse. This included not only the persistent bombardment of letters despite the Schlosses and others attempt to demonstrate to the estate that what they were doing was fair use. But even more troublingly, the estate's claim that Schloss and others could not use medical data concerning Lucia Joyce. Now, this medical data was not protected by any copyright, certainly any copyright owned by the Joyce estate. So this was an attempt to say you can't use this material even though I don't own a copyright over it, but I'm using my copyright power to try to bludgeon you into refusing to do so. It even went farther than that, and our allegations included the Joyce estates attempting to bar or discourage Carol Schloss's physical access to papers in archives, which the Joyce estate had no physical ownership over. The archives and the universities owned them. So again, it's the use of a copyright power here in intellectual property, in this case to try to bar access to physical property over which the copyright owner has no control. You see how this attempt to pivot off your copyright into other areas that you don't have rights in is really, I think, at the core of the emerging doctrine of copyright misuse. I would like to say that we had a precedent in place and a published opinion saying that what the Joyce estate had been doing was copyright misuse, but the case settled. The Joyce estate didn't want to go forward with it. They threatened to file a covenant not to sue if we didn't settle it, and of course if they'd filed such a covenant, the case probably would have gone away pretty quickly without any benefit really to the client except the covenant not to sue. So what we did is we got a settlement that got us all of that, got Carol Schloss all of that, the covenant not to sue, but also allowed her to do other things such as to issue her website in paper form within the United States so she could actually publish it in print. But we did get two published opinions out of the case, one in which the court denied the estate's motion to dismiss. And there's some very good language about the copyright misuse. Of course, they attempted both to dismiss and to strike from our pleadings the copyright misuse claim. The court said, no, that can go forward on these facts. I think that's a very good precedent to have on the books. We also then, on the basis of the settlement, which we felt was so generous to us, to our client, that we could move for attorney's fees under the copyright statute, we did so, and somewhat to our surprise, the court granted attorney's fees and said the Joyce estate has to pay your fees. So we're now litigating that aspect of the case. And you can imagine that that will be hotly litigated. But it's an aspect of the case that I think is very interesting, and we'll see to what extent copyright misuse may play a role in that determination when it becomes fully adjudicated. I just wanted to mention a few details about copyright misuse, really kind of lawyer type issues. I've mentioned before that the standing of a party alleging copyright misuse, or as it were, the evidentiary standing, is very broad, and courts have recognized this. You just heard me say it in the Joyce estate case. The court specifically said that Schloss could not only allege that there had been copyright misuse directed at her, but that there were all these other scholars, and of course we had a myriad of examples, who had been threatened in one way or another. You know, projects, internet projects of all sorts have been shut down on the basis of what we thought were inappropriate threats. So this was going to be an opportunity, and the court was going to permit it to do a great deal of discovery on bad behavior involving other targets. So, and of course, I mentioned the laser comb case, and there are others in which the defendant really can bring to the attention of the court bad behavior involving other targets, and that is a very broad kind of whistleblowing role that the defendant can use self-servingly in the copyright misuse context. And just a few limitations on the doctrine. It's not something that anybody can use any time. There has to be, the courts say, a nexus between these anti-competitive actions and the copyright owner's power, copyright power, and or between the copyright owner's actions and the Copyright Act's public policy of promoting creative expression. In other words, there has to be some connection between this power that you have as a property owner and your attempt to misuse it. Can't be just sort of anything. So that, for example, if, and this is a case that's well known, the Alcatel case, the Altera case, when the plaintiff in that case sued for infringement of its semiconductor chips under a separate set of statutory provisions, separate from the traditional copyright law, and the defendant in that case raised a defense of copyright misuse, the court said no, what's at issue here are the semiconductor chips, not the related copyrighted software that the plaintiff owns, and so there's not that nexus that you need to have. So another set of limitations that have been placed on the doctrine is you can assert copyright misuse as a defense, an affirmative defense to a copyright infringement claim, or as a basis for declaratory judgment relief if you've been threatened by a copyright owner, but you can't bring it as a counterclaim against the copyright owner. You can't bring it as a defense to a state law claim, or in the absence of an allegation of copyright infringement. So it's not as though you can just sort of blow the whistle on bad behavior in the abstract. It has to be related to your being threatened or sued for copyright infringement. The important thing to know too is, what happens if you are found to be a copyright misuser? What happens to your lawsuit and to your property right? Well, it doesn't invalidate the copy. It doesn't destroy the property right that you have, but it does render the copyright unenforceable for the period of the misuse, or as some courts put it, until the misuse has been purged, or the misuse and all its effects have been purged. What exactly that means we don't know very much about, because most of the cases have not dealt with the afterlife of a copyright misuse conduct. But it will be interesting to learn when courts get to the point of policing some of this this after period, what a copyright owner would have to do to purge its misuse. Judge Patel in that Napster case said something I thought was a little puzzling. She said that the doctrine does not prevent plaintiffs from ultimately recovering for acts of infringement that occurred during the period of misuse. And what she seemed to be saying was that if the copyright owner sort of went on its good behavior and showed that it had purged its misuse, that it could then eventually come back around and sue that same defendant for copyright infringement. Which I thought, well, what exactly then would the copyright misuse doctrine serve if there was only delayed punishment, or if there was only temporary punishment of the copyright owner? Does it mean that the owner could recover from the defendant for infringements established during the misuse if they had been good for a while after? Would it mean that if 3 years had gone by, that the statute of limitations would somehow be told so that the copyright owner could still come back in and sue that same defendant. If the answer to all of these is yes, then I worry that the sting of enforceability would be lessened. You wonder if the copyright law's policy of spreading expression would be served by such leniency. And I should say that's not something that everybody said, but Judge Patel did say it in this case. And so you wonder what kind of teeth that dictum would have in later cases. Another of the limitations that some courts have put on this is they've said that if the person bringing the copyright misuse defense itself is guilty of unclean hands in some way, it might be prohibited from bringing the copyright misuse defense. Some courts have said no, that's not right, and it may be that as this emerges, it may be that the party invoking equity will be the focus of any unclean hands. So, for example, if the copyright owner has sued for an injunction and the defendant has raised a copyright misuse defense, the primary issue here is whether the injunction should issue, that is, whether the plaintiff's hands are clean, and therefore it's less important that the defendant's hands be clean. If there is only a copyright infringement action for damages, maybe the raising of a copyright misuse defense will focus the equity and clean hands issue on the defendant. But we don't know exactly. But just to say that if you're going to raise the defense of copyright misuse, you better check your own hands. That would be a good idea, to be prepared for that comeback. And then finally, I wanted to just mention attorney's fees again. Of course, that's an issue in the Schloss case. But it's come up in some other cases too. And the Bond v. Bloom case is a very interesting version of copyright misuse and attorney's fees. In Bond v. Bloom, the plaintiff was a fellow who had written an unpublished memoir in which he described his brutal murder of his father. In a custody battle, his wife's attorneys, former wife's attorneys, got hold of that manuscript and got it entered into evidence as part of the custody issue. Whereupon the plaintiff, the writer of this memoir, brought a copyright infringement suit against a whole bunch of people, including the attorneys of the former wife. The court was outraged by this, and I think you can see why. I mean, not only are the facts so dramatic and so incredible, but what the court said was, first of all, the court found that this use of the manuscript in the custody court battle was a fair use, as you might expect, but also found that this was really a dramatic example of copyright misuse. Because the copyright owner here was not trying to vindicate any economic rights. There was no question that the economic rights in the manuscript were not being threatened by use in a custody battle. But the plaintiff was attempting to extend that monopoly power to suppression of facts to be submitted to a court. And this was something that the court found to be simply outrageous. And when it awarded attorney's fees to the defendants, noted that the attempt to suppress the underlying facts stated in the manuscript was an example of, was no attempt to safeguard the creative expression. It was simply a vindictive attempt to suppress facts. Therefore, in the court's discretion, attorney's fees, and in the copyright context, attorney's fees are always discretionary. They don't have to be awarded to a prevailing party. The court found that this was a major factor in favor of doing this. And in the wire data case, the Judge Posner case that I mentioned to you, the court awarded attorney's fees to the defendant in that case, wire data. And although, as I noted, the case did not go off on copyright misuse, when it came back to adjudicating the the attorney's fees, the court said, now we will consider this bad behavior. As Judge Posner put it, plaintiff's conduct, whether the plaintiff's conduct rose to the level of actual copyright misuse is something we did not reach in our previous opinion, but we made clear that it came close. And an award of attorney's fees to the defendant is an appropriate sanction. So you see in both bond and wire data, the plaintiff's attempt to really to use the copyright to suppress facts was the leading consideration in awarding attorney's fees. And let's just hope, we hope anyway, that that will be a similar, there will be some kind of similar finding in the Schloss-Joyce estate case. So copyright law, copyright misuse is an important emerging doctrine. In addition, obviously, to the defendant's arsenal of defenses. It's something that both transactional attorneys and litigators need to know about in order to advise their clients carefully, because obviously if you're a copyright owner, you want now to be sure that in setting up any lawsuit or in protecting your rights, you don't cross over into that zone that might be copyright misuse. At a minimum, the doctrine reins in some of the more overreaching behavior of rights holders in a time of expanding intellectual property rights. Thank you. And I'll be happy to take any questions you might have. Tom? Uh-huh. Yeah. That's very interesting because, you know, it seems to me that that falls into a paradigm that I can think of. I mentioned, for example, these older movie theatrical release cases. Some of those had to do with a kind of anti-competitiveness or a kind of I don't know, a kind of tying situation where, for example, if you were an outdoor movie theater and you bought these bundled packages of movies, you would get 3 movies you wanted, and you also get 45 movies that were nobody wanted to watch. They were B or C movies that were old and worthless. And there was some successful anti-competition lawsuits brought against that, where this was essentially, you were bundling or tying in stuff that people wanted to buy with a bunch of stuff that they had to buy in order to. But I didn't see that raised in Napster. It's an interesting idea. Right. Yeah. It's if that troubles you, that sort of defense might not have been available if it was thought of. This new copyright bill that has just come out, enhancing statutory damages, focuses in part on enhanced damages for infringing entire CD albums as opposed to the single songs on it. So that's an issue that has come up in the damages aspect of copyright law too, and I think you might be a little disturbed by the enhancement of damages for infringing entire albums. Yeah, Gary? It's kind of a private attorney general concept almost, or a qui tam kind of situation, right? Where you have the right to enforce a public policy, even though you yourself might not personally be affected by it. But exactly, I think it is. And of course, you have to be involved by being sued in the first place, so there's some sort of nexus. But after that point, you have this broad evidentiary standing to try to show copyright misuse. Another reason why copyright owners may want to be careful, because they not only have to consider their behavior vis-a-vis this person, this potential defendant, but against everybody, because that potential defendant has the opportunity to blow the whistle as regards everybody else. Yes. In the back first, then we'll come up. It's not exactly clear because so many of the cases have not actually gotten to the point of that issue, but it appears that it can be against anybody. And it would be consistent with punishing the copyright misuse behavior by simply making it a non-usable property right for some period of the continuing misuse. In front. Don't ask difficult questions. I can say only this, and that is the document that was drafted by the defendant's attorneys, and we had 11 hours of negotiation, and this wasn't in the document. Now we didn't. There was absolutely. You can imagine the reaction of the other side, which was Jones Day, incidentally, of L.A., when we said we were going to move for attorney's fees, and they were outraged. You've negotiated this agreement and all this stuff. But, there had been, nobody had tried to pull the wool over anybody's eyes. We simply were negotiating a document that did not include that term. And I can say that without revealing anything about a confidential settlement, because one of the terms of the settlement was that it be a public settlement, which is now available on the web on Stanford University's website. So you can go look at the settlement document, which does not contain any such terms. Absolutely, I think that there would be no attorney's fees. We wouldn't have moved had there been parties that shall bear their own fees. No, absolutely. Yeah. Mm-hmm. Right. Yeah. Uh-huh. Absolutely, and and there is this. I mean, you don't have the Article 3 problem because you're in there. There's been actual harm alleged and redressability and so forth, as in general. But it's just that you have this opportunity now to say, well, take a look at that behavior over there. Okay. Yeah. Yeah. Somebody challenged them on it. They said, well, we'll solve the issue standing. Yeah, it's a good question. I really thought for a while that they were going to file this covenant not to sue, and then, have a quick motion for summary judgment saying that there was no case left, no case or controversy, the thing was now moot. They didn't do that. I'm not sure exactly why. There may have been psychological reasons. Stephen Joyce is somebody who is passionate about, he's bragged off, and he has brought lawsuits successfully in Europe, and he's passionate about being able to say, we've never lost a lawsuit, we've never done this. So he may psychologically have preferred a settlement agreement where, there is the term that parties don't admit or deny liability, to a covenant not to sue that he thought might have been construed as running up the white flag. I just don't know exactly why they backed off of that. But we took the opportunity to say, let's not have to do a whole summary judgment motion on this. Let's just do a settlement agreement if you're determined to covenant not to sue. And they said, okay, come to the table. I don't know what. It's funny because they say that talent skips a generation, and here neurosis clearly skipped a generation without the talent, because Stephen, and I don't mean to, but Stephen Joyce is not somebody who has really been a very creative personality, but his grandfather was very neurotic in addition to being a major talent, and he seems to have inherited all of that neurosis. I don't think necessarily the psychosis, but he's a very angry fellow. I'll take this one and then we'll go to Tom. Yep. There really is no It's possible that the doctrine will become codified at some point. I don't think very soon. Now, this happened in the patent misuse context because patent misuse was a common law defense for quite a while, and then it became codified and in some ways diluted or reduced because now in order to show the patent misuse, you have to, which is almost always there, a kind of anti-competitive, antitrust type thing. You're governed by the rule of reason, as in antitrust law, and you have to show that there's not just a per se tie-in or price fixing or something like that, but that market power has been abused. You have to show the various reasonableness factors. That could rein in. I mean, if that sort of thing was applied to copyright misuse in a codified form, it could be somewhat reduced and diluted or tamed. We don't see that happening anytime very soon. But there is only one other statutory basis that I know, and that is if you are doing a straight-up antitrust type of copyright misuse claim, then of course you would go to the antitrust statutes for that basis. But there's no other codified version I know of. Even though fair use, which I compared copyright misuse to, has been codified as of the 1976 statute. Tom, you had a question? Yeah, so you would have a how-to to address any problem with the Joyce estate. Yeah. As it is, there's a how-to because it's all on the net now with the settlement agreement. So, but you're right. I think that probably was another reason they wanted to avoid it, and maybe also just to avoid additional costs because they would have had then to move for some affirmative relief after filing the covenant not to sue, and we might have opposed that or might have dragged on a bit. So they were already piling up fees that they were considering. He doesn't, because Stephen Joyce really doesn't and hasn't historically. He's made a lot of threats against U.S. scholars, but he's not really brought a lawsuit in the United States, and I don't think that's his comfort zone. He lives in France. The estate is based in Britain, I believe. And they're more comfortable over in Europe bringing lawsuits where, incidentally, the doctrine of fair use, or what they call fair dealing over there, is considerably narrower than it is here in the United States. So, I don't think they want to tangle with the sort of defenses that defendants have over here in copyright suits. Yeah? Yeah. Well, one of the things that Professor Schloss and I have been talking about doing is maybe trying to do some kind of case book, just a case book on this case that is assemble the pleadings and all of that. And I wonder if no. Yeah. So a business method a sort of a business method patent on how you do a lawsuit or how you proceed. Interesting. Yeah. I mean, suppose you perfect a 50-page complaint in a class action environmental pollution case. And this really is the form that it ought to take. I mean, it's really efficient. It's right. Can nobody else use that form because you have registered a copyright in it? That's an interesting, it's an interesting thing. There is the doctrine in copyright law of the merger of idea and expression, and when there is no other way to express an idea than this one form, you can't enforce the copyright because then you would be getting a copyright over an idea, which you can't have. So. Yeah. Now, copyright misuse is becoming as common as, asserting an unclean hands defense or anything that you sort of throw in as boilerplate in a copyright infringement case. For example, this recent Harry Potter lexicon case, which, my colleagues at Stanford helped litigate. Well, they lost that case. The defendant there lost that case on summary judgment. It all became a fair use case, as you probably know. But there was originally a copyright misuse defense alleged, but that was dropped before it reached the summary judgment stage. So it's something that is kind of being thrown in with the kitchen sink, I guess they're saying, I say throw in with the kitchen sink because that's what the Obama campaign has been saying. The McCain campaign has been doing, including the kitchen sink. So. Joe the kitchen sink. Yeah, Joe the plumber. That's right. Yeah. Thank you.